Morning, everybody. Thank you for joining us today for this Small Business Boot Camp. I'm Robert Theobald, Small Business Ombudsman and Vice President of Small Business Services here at the Arizona Commerce Authority, and we are very glad to have you with us today for this webinar. One of the things we like to do when we first start out is have everybody post up in the chat where you are tuning in from. We love to see where throughout the state we have our participants from. So I see Glendale and Lake Powell, Page. We got Kingman, Avondale, Yuma, excellent. Phoenix, Maricopa, Flagstaff. All right, again, post up in the chat where you're tuning in from. We'd love to see it. I see we get Mesa, Buckeye, Chandler, Gilbert. Awesome. We have a great group from around the state. We're excited to have you with us. Again, you can still go ahead and post up where you're tuned in from. But we're going to continue on with some of these intro slides and topics. For those that are new to the boot camp, we could not do these boot camp presentations without our community partners. We appreciate their time, their effort, and their sharing of their expertise with all of you and giving back to the community. The Small Business Boot Camp is designed to help small businesses prepare, plan, and grow their business. It is a virtual webinars. Sometimes we do some hands-on workshops with local experts, but most of the time we do it virtually so we can reach all four corners of the state and sometimes beyond the state. And then one of the great things we do with these boot camp webinars is we record them. And you can find in the content library well over 300 recorded webinars that help support the idea of prepare, plan, and grow. You can access the recording and the slide decks from our presenters. So there's some great resources there. So please check that out. There's no cost to access the content library. Also, the ACA has a number of other programs that you can leverage to help support your business. You can scan that QR code. It'll take you to the accommerce.com/programs webpage where you can find all these and more. One of the ones we do like to highlight is the small business checklist. This checklist is an interactive tool that helps small businesses or businesses planning to scale and grow their business into new areas identify the commonly requested licensing, registration, and compliance requirements at the local, state, and federal level. The checklist itself is very detailed. There's a ton of information. And so we also have our virtual assistant, Sally, that can help with some simpler questions with a little less detail. But she's got this great AI mind in her that can help navigate some of that stuff. So check out both those options. And if you have questions after using it, you can leverage both Sally or our contact us button to get a hold of us to answer those questions. So one of the things we also want to mention is the applications are open for the Small Business Digital Academy. The Digital Academy is a multi-week course that teaches entrepreneurs and small business owners how to utilize websites, social media, e-commerce, SEO, and analytic tools to promote their business digitally. This is a great program. We've been doing it for over 4 years now, and we constantly tune it and tweak it to the current way things are working. As we all know that social media and SEO and all those algorithms and stuff change, and our expert mentors that are part of this program stay on top of that and share all the updates. So it's a great session. We hope you can join. There's no cost, just the commitment of being there for the 3 weeks and being active in the sessions. Also, if you're looking to fund your business, our partners at Prestamo CDFI are hosting a Funding Your Business workshop. This is going to be virtually on February 12th. You can scan that QR code, and Faith is going to post in the chat the link if you want to attend that and understand the basics of preparing for a loan, knowing most people don't go take classes on how to get a loan for a business in high school or in college. And so this is to help you understand the language of banks and lenders so you can be prepared properly when you do seek that loan. Also, we got a great lineup upcoming for our sessions. So February 18th, see how AI is transforming email, social media marketing, and then building trust and authenticity with an AI-focused approach, and then social media distribution roadmap. So we've got a bunch of great marketing-related sessions coming up. We hope you can join us for those. And with that, we're going to jump into today's session. We have a returning speaker, Brian Burt from Snell and Wilmer. Brian's probably done more boot camps than any single individual because we love this session and we like to have back to do it a couple times a year because it's provides such an impact and helps businesses understand things that they may not be doing correctly that can really impact you, but impact you at the wrong time. And so we want to help identify those items and help you see where you may need to get some help. So we'd love to have Brian with us. He's a great partner. And so I'm going to stop sharing my screen and turn it over to Brian. We're sure you're going to have some questions. So if you can place those questions in the Q&A at the bottom of your screen, there's two places. There's the chat and there's the Q&A. Please do questions in Q&A and we can save the chat for some additional interaction. So with that, Brian, it is all yours.
All right. Thanks, Robert. Appreciate the kind introduction. Really excited to be here again to talk about how to avoid the top 10 legal mistakes that can destroy your business. So we're going to pack a lot of good stuff into the next hour or so. And as Robert said, feel free to throw some questions in the chat box. And for those who are attending today's program, I'm happy to offer a free initial consultation to chat about any of the topics we're going to cover. So feel free to shoot me an email. My email's on the bottom of the slide there, and I'd be happy to connect up with you after if you're interested. So with that, we will jump right in. Just a little bit about the firm for those who might not be as familiar. We've been around for a long time here in Phoenix. We've got over 500 attorneys in our 16 offices, about 200 and some here in downtown Phoenix. And we're a true full-service firm, so all the resources you might need to start, grow, and hopefully sell your business at some point. More information available on the website, and try to do a kind of collection of articles of interest to entrepreneurs, mostly non-legal stuff that we post on our blog. So feel free to check that out. Try to do that at least once every week or two. My role at the firm is to head up our emerging business group. So I get to spend all my days working with entrepreneurs and their companies, kind of all shapes and sizes, in a variety of business type transactions. You can see a few of those on the screen here. Been in Phoenix for almost 21 years now. Been practicing for over 26 years, and enjoy, again, working with lots of different individuals and companies kind of from start to finish throughout the company's life cycle. So we're going to talk today about kind of 10 areas that you can get yourself in trouble. And as Robert mentioned, we've been doing this program on a number of occasions for the Commerce Authority. And, unfortunately, I guess, I don't know if it's unfortunate, but the things don't change, right? The same issues that we see folks get wrong continue to pop up almost on a daily basis. And so I don't know if that's good or bad, but we're going to talk through those today. We've got some fresh updates for those who may have attended a previous program. And we're also going to talk about what I call myths on the street, things that you hear about from your buddies, you see on the internet, you may read about and say, well, is that really accurate? And so we're going to kind of go through a number of those things as well. But 10 categories of items, and time permitting, kind of give some horror stories, things that really happened in my practice that I've seen. I think that helps drive the point home as to why not to do some of the things we're talking about. So number one, selecting the wrong form of corporate entity. So some of you may be just getting started, others may be in business for many years. And these are the options you have. You can be a corporation, an LLC, limited liability company, or partnership. Almost nobody forms a partnership these days, so we really are focused on corporations or LLCs. You notice the reference to an S corporation. That's a pass-through tax election you do to just get taxed on one level. And one of the first myths on the street is, well, I hear that we've got to be a corporation in order to maximize my corporate shield, maximize protection from creditors as to my personal assets, and that is not true. So to the extent that you want to be in an LLC, and all things being equal, that's my kind of go-to entity of choice because it provides, again, same liability protection if you start and operate it correctly. It has one layer of tax, which is nice, unlike the C Corp, and it offers kind of maximum flexibility to structure all the things in your company from a owner relationship standpoint. The S Corp also offers pass-through tax treatment. So some of you may be in the S Corp structure. You may have heard from your accountants, hey, that's a good way to go. And there is some withholdings benefits. So there is some benefit to being an S Corp. And depending on the nature of your company, that may work just fine for you. But for those who are looking to grow the company, raise capital, and do some other things as you go through the life cycle, the S Corp can be very restrictive. You can only have certain types of U.S. resident humans invest in the S Corp, so very difficult to raise capital. And there's other restrictions as well that as you grow the company can start to make, that particular entity look kind of the disadvantages outweigh the benefits, I guess you could say. So depending on where you're at, you may think about either starting in the LLC structure or converting if need be. There's only a couple of instances where you've just got to be a C Corp, again, notwithstanding what you may have heard out there. One is if your company is going to go public, that's very, very few people will do that as an exit strategy. The other is if you're seeking capital from certain types of investors, institutional investors who insist on the C Corp, and those certainly are out there, but very few people will ever take institutional capital. It's less than 1%. And so for the other 99+% who aren't going to need to get to a VC or a private equity firm and are going to find themselves funding the company either through friends and family, through themselves, through loans of various kinds, the LLC can be a great structure. To the extent, and all the things we're going to talk about today, they don't get better with time. So to the extent you've got an issue today or you've identified something and say, you know what, I might want to take a second look at this, it doesn't get better with age. This is clearly one of those. And the first kind of horror story is we had a company that was a local company here in Phoenix, up in Scottsdale. They had started out in a C Corp, really didn't know why they did that, but they did. They transitioned it to the second generation, which is where we came in. And we were asked by the second generation to help transition it to the third generation of employees. And the company at that time was worth 20 million, so a very successful company. And there was no way, notwithstanding all the efforts we made to try to work through it, there was no way to get that C Corp to become a pass-through entity because they needed to do it very quickly. And there was no way to change that up and get rid of the double taxation for generation 2. So they ended up having to pay a second layer of tax on $20 million worth of value. That's millions of dollars of extra taxes that you simply didn't need to pay, but they hadn't taken the time before it was too late to do some restructuring, whether make an S election, which can take 5 years to take effect, or facilitate a transition into an LLC, factoring in the various issues you need to focus on. And so, again, millions of extra dollars in taxes. So if you're sitting in an entity today, you say, you know what, I'm not sure why I'm in this, or I may want the benefits that I'm hearing about that maybe I can't get. Maybe I want one layer of tax. It may be a good time to think about here in the new year, how do you pivot from where you are today? Number 2, not protecting your corporate shield. So lots and lots and lots of entrepreneurs filed the articles, whether they form in Arizona, Delaware, or some other state, and then they stop. And they assume that, hey, I filed the articles of organization to be a LLC. I filed the articles of incorporation to be a corp, and I'm good. And so that's it. I don't need to worry about anything else. And that's unfortunately not true. So just having an entity in existence doesn't guarantee personal asset protection. What you have to do, and this is one of those fancy legal words, is you have to prevent piercing of the corporate veil. That simply means keeping your corporate shield in place to ensure that the creditors, and the longer you're in business, you will have folks make some claims, either threaten to sue you or actually sue you, just the kind of price of doing business. You want the worst case always to be that you bankrupt your company and go home and do something else. You don't want the worst case to be that you find that they pierce through that corporate shield and get out your house, your kid's college fund, your retirement savings. You don't want that to be what happens. And so you need to take some steps to do things. And again, very few entrepreneurs focused, rightfully so, on growing the business, generating revenue, getting customers, not so much on the legal side, oftentimes don't know not to do these things. One is to separate your company from your personal stuff. So you have to have a separate bank account for the company. You can't fund everything out of your personal account, both personal and business. You've got to, get your tax number. If you're lending money to your own company, create a promissory note to pay yourself back and what those terms look like. So you want to set up a separate entity, and both in practice and in theory, and make sure that those dealings there's a very clear line between that personal and business side. Many entrepreneurs tend not to do that. Undercapitalization, you can't form the company, throw a couple bucks in and hope that revenue gets generated maybe in the next 2 or 3 months. And with that revenue, you'll pay those initial creditors, your landlord, your initial employees, your friendly neighborhood attorney, etc. And if revenue doesn't kick in, you'll feel bad, but you'll kind of shut things down. That will not work either. And fraud, and we're assuming people aren't inclined to do that. But what we're talking about here more is really a situation where maybe you left your employer or you got let go. You figure now's the time to start your entrepreneurial journey, but you have a non-compete and you say, you know what, I'm going to set up a company because that company didn't sign the non-compete. I did personally. So I won't personally compete, but the company will. And that's just trying to use that entity to get around your personal obligations, and that's not going to work either. So even if you do the things that we just mentioned, there still can be some personal liability in a few categories I want to quickly highlight. One of those is if you guarantee stuff. You've got to monitor and try to get off or trade collateral for those guarantees. Don't forget that you did it. You may need to do it for an SBA loan. You may need to do it for your lease. So there are places where it needs to happen. You want to make sure that you monitor it and get off those. You also want to make sure that you're not engaging in bad acts. Obviously, if you get down the hallway and you assault somebody in the kitchen, that's going to cause some trouble. But what we're not thinking about often is things and rules that maybe you're not aware of, particularly in the employment space, where failure to follow those rules can lead to some personal liability. A big one is failing to treat people as employees and alternatively treating them as independent contractors. States are tightening up on that, particularly places like California, but all states are taking a much closer look, and failure to characterize people properly can generate some personal liability. So you want to really pay attention to those areas and try to cut your exposure. The horror story here, I think it's the worst one of the day. Actually, it's not the worst one. So second worst. But the horror story here is we had a company, this was a while back, and they were very successful, local business, looking to sell. We were vetting some opportunities, some term sheets for about a $50-60 million deal, I believe. And they had a whole bunch of millions of dollars worth of personal guarantees. And we said, you know what, you might want to get off those guarantees because, who knows what happens. And, why don't we just go ahead and take care of those? You have the money to pay those off. The owner said, you know what, it's kind of a pain to pay the banks back. And there's a lot of paperwork. And you know what, we're going to close this deal. We feel pretty good about it, in the next 2 or 3 months. So let's just wait till closing. We're getting a lot of money. We'll pay it off at closing. Let's just save some administrative hassle. Well, we said, all right, your call. Well, that was the fall of 2008. And no one knew what was coming. Maybe some did, but this client did not. And we didn't see what was about to happen. But obviously the market crashed. Their particular industry was hit particularly hard here in Phoenix. They went from a $60 million sale to zero within 60 days. And the banks did not say, well, we feel bad you lost your company and that big payday. So you know what, why don't we forget about those guarantees? They said, hey, it's time to pay us. And so it went from a huge payday and a retirement to almost going personally bankrupt, having to pay millions of dollars of personal guarantees that he could have gotten off of just 60 days before, could have had the cash to just pay those off, didn't do it. And so just a thought to keep in mind as you work through your process. So number 3, putting all your corporate eggs in one basket. So whether you are just getting started, which is a great time to do this, or you're at a point where the company's been around for a while, but you maybe haven't thought about doing this, maybe a time to take a couple minutes and think through your structure. There are a number of ways to kind of build fences around your operations, your assets, to protect those things that are important or shift risk in ways that make sense. A good example would be you own your operating business. You decide to buy the real property out of which your company operates. Maybe it's a warehouse, maybe it's something else. And if you have that real property and you take it and you form a separate company that you would own as well, and then you tuck that real property into that new LLC, for example, and then you lease it to your operating company, you have shielded, if done properly, that real property from claims that may arise in your operating company. So if you get hit with a big claim from an employee, from a customer, vendor, what have you, that real property is tucked safely away in that other company, and the creditors can't get at it. Same with, you could do that with intellectual property. You could do that with equipment, any other key assets that you want to shield from the day-to-day risks associated with operating your business. You can also kind of carve out the business and say, you know what, we're entering into a new jurisdiction. Could be a new state, could be a new country. We're entering into a new line of business, and that poses a much greater risk of liability. So we're going to start a new company to operate out of that new place or operate that new line of business and keep our existing company, which has less risk based on what we're doing, more shielded from those potential issues. So lots of ways to create it. You can do a holding company structure, you can do an affiliate structure, but the point being, ways to shield yourself. Now, you still have to pay attention to the fences you create, just like we talked about for an individual single company, you have to separate personal and business. Here, the same thing. You can't create the structure and then ignore it. So for example, you can't just have a real property but have no lease between the two companies to lease your real property to the operating company, no payments. It's just, kind of in name only. That won't work. You have to at least take steps to put in place, it doesn't have to be a 400-page lease, but a short form lease, and actually pay yourself a market rate. And if you set it up appropriately in terms of pass-through entities, et cetera, you're not going to end up paying any more in tax, kind of a wash, paying one hand, paying the other, but you will get critical liability protection, which again, for those who've gotten involved in disputes, is could be quite attractive, and certainly, protecting valuable resources, assets, et cetera, lines of business from when those creditors do come knocking. The example here is one that actually ends on a good note, so they're not all bad, but I think it's illustrates the point and is, I think, pretty common because lots of you do more than one business. So we had a client who was in a particular business, operated Arizona, California, some other places, saw that business kind of winding down, so they put together a new software platform in the existing operating company, didn't think to separate it out, said, hey, we're going to build this, pay for it with the proceeds. It was just a sole owner. And we'll eventually launch the new business and pivot out of what we're doing now. Well, unfortunately, got hit with a class action in California as they had kind of built up the software platform for this new company. And once they got hit with that, then those plaintiffs, if successful, could have gone after, as an asset of that company, that new software platform that they paid a few $100,000 to create. It was quite an undertaking. The only way to get that asset out of the company was to replace an asset worth, call it $300,000, with cash equal to $300,000. And so they had to essentially agree to buy their own software, set up a new company and buy the software out of the operating company. Otherwise, it would have been a fraudulent transfer. So we had to set it up. They made a couple of payments. Again, this ended on a good note because they settled the lawsuit, and they ended up, it was kind of a wash. But had they not settled it, they would have essentially had to pay double for that piece of software because of its origins within that existing operating company. So just an example of how that can go sideways pretty quickly, and didn't anticipate getting sued, let alone a class action, but those things do happen. I'm going to check real quickly here and see if we've got any questions. If you do, it looks like none so far. But if you do have some questions, please put those in the box. Well, one just popped up. Can you explain when a PLLC, so professional limited liability company, is used when you are in, for example, starting a business where there's licensure, think about as a in the medical space. We just set up a PLC for someone who was a nurse and providing services to various doctors, hospitals. So it's typically in that space. In Arizona, there's not a huge kind of difference between an LLC and a PLC. People often do it more for kind of a marketing purpose where they say, hey, we want to be known as a professional limited liability company. Gives you a little kind of additional cachet there with it. But legally, there's not a huge number, really a whole lot of benefits. But there are some limitations as to who can own it. Certainly in certain professions, the licensed party has to be the sole owner. Again, it varies depending on what type of industry you're in. So it does come with some limitations, which again, if you're the licensed party setting it up, no big deal. But from a, what does it give you standpoint, again, really more of a kind of marketing thing than anything else. So hopefully that answers your question. So this may be my favorite slide. If you have a partner of any kind, you absolutely have to have a shareholders operating agreement. And for those on the call that say, you know what, we're in a family business, I'm in business with my brother, my kids, what have you, we'll work it out. Well, one of the top 3 causes of litigation is always shareholder disputes. It is forever since I've been, started practicing. This is a perpetual issue. People will fight. And for those in family businesses, we can tell you from lots and lots of experience that those are the nastiest disputes. You've got all the business dynamics, and then you've got the family issues layered on top of that. We're just about to meet a new client today, in fact, that is in it's almost hard to believe, but her own son is going after her in ways I've not seen before. Just brutal situation. And you would think, how does that happen? How does it get to that point? But that's one that literally is just popping up today. We see these all the time. I typically am working on a few on my plate at any given week or month, and they are extraordinarily expensive to get resolved. They are even more stressful than just the dollars. It's just the stress that goes with the dispute. And in many, many cases, I'd say the vast majority of the cases, it could all be avoided if you put together a shareholders operating agreement if you're an LLC, shareholders agreement if you are a corporation, that really eliminates or greatly reduces the likelihood there's going to be problems. Most people say, again, one of these myths on the street that, hey, I'm not going to worry about that. The state statute for corporations or LLCs, that's the playbook. And if we have an issue, we'll go to the playbook, go to the statute, and it's going to give us the resolution. That's not true. So the state statute, whatever state you're in terms of state of formation, only answers maybe 20% of the issues that you're going to confront. And even those aren't answered in ways that often make sense. So you are stuck in a position where 80% of the time, there's no outcome that's kind of preordained in the statute. And you're left figuring out, what do we do? And that's what leads to disputes. Every partner will disagree. Hopefully it's just a business disagreement. You work it out. But the purposes are what you see on the screen there, to understand and align expectations, which often are not aligned, allocate all the different rights, management, economic, transferability. All those things are, again, not governed by the statute typically. When you do have disputes or life happens, you want to preserve enterprise value. I can't tell you how many companies have been, totally destroyed. Multi-million-dollar companies, people have spent years building up. There's a fight that starts and they end up disappearing. It's just fatal to the company's existence. And if it's not fatal, people spend incredible amounts of money, even if you don't go to litigation, but certainly if you do, fighting these battles that often could have been resolved by turning to the playbook, the operating or shareholders agreement, and saying, hey, when we started this, this is how we agreed to resolve this issue. So let's not worry about it. At the end of the day, I could give you and fill the rest of the time with examples of all the stuff that has happened. But I think the best one, and I think I've shared this for the past presentations here with the Commerce Authority, probably the craziest thing you'll hear all day, but I think gives you a clear understanding of why the state statute and kind of relying on that is not going to get you from A to B. So we had a situation where we were working with a client and they went off on their own for some reason and created their own operating agreement. It wasn't that bad, but it had a lot of holes in it. And so we we had gotten a call from them saying, well, we've got some issues here. What had happened was they had an individual who was on their board. If you look at this guy on paper, great resume, older gentleman, had been on the board, was an investor in the company, owned some shares in the company, and they were going out to raise capital. So they were rounding up the troops and saying, hey, we need to kind of call in all the team, and we'd like you to help let folks know that this offering is going to be happening, reach out to your contacts, etc. They couldn't get this guy on the phone for some reason. He didn't live in the state they were in. And so they just Googled the guy and the CEO and said, hey, I don't know if he moved and didn't tell us, but we wanted to find him. So I Googled him, and they were astounded. What popped up was news stories about this guy who had apparently something happened, and he decided to go and try to take out his ex-business partner and his ex-wife. He ended up running into the ex-wife's brother, I believe, shot him, didn't kill him, thankfully. And I think the thing was kind of caught on a home camera or home, surveillance cameras. So suffice to say, you would think in that circumstance, trying to kill two people, almost killed one, that it would be fairly easy to get this guy out of the company. Obviously, it wasn't going to be good for business to have a attempted murderer be on your board and owning pieces of your company. And so thought was we probably need to excise this guy pretty quickly. There has to be an obvious an ability to expel a owner. In this case, it was an LLC in that circumstance. Well, guess what? There isn't. There's nothing in the statute that says, hey, you try to kill people, your partners can kick you out of the company. And so with lots of negotiation, obviously he was focused on other things rather than our needs. Was able to get him to stand down and take it off his social media and just kind of part ways. But if that example doesn't give you some insight as to how important it would be to put these documents in place, and it's not just a buy-sell, by the way. People say it's a buy-sell. That's a component, but that's not the whole kind of meat and potatoes there. It covers all the other issues, and if done correctly, in situations like that, and obviously, hopefully that we don't see that again, but in much less significant, but still important to you situations, you have it in place. More tame example we see all the time is family businesses where, the family members, or sometimes there's two families, never sat down to figure out how do we transition the business? Do we sell it at the end of the day? Do we transition it to the kids? And if there's not agreement on that, that can lead to all sorts of chaos as you go to figure out what the exit event is. And we've seen people in business for 20 years that never sat down and talked about it, let alone baked it into agreement, and now are figuring out how do we preserve value but transition it without having acknowledged our shared objectives. Next up, probably my second favorite slide.
Hey, Brian, real quick, we
Sure.
have a question that ties with that last slide.
Okay.
It's a real simple question, so.
Let's see here. Are there any resources for writing an agreement? That's a great question. If done correctly, they are very specific to your company, your situation. There is no single kind of template. They are really one of the documents that, unlike others where there's kind of some forms out there, there's some precedents. These are really specific. I write them all the time, and it completely depends on what how many parties are involved, what they agree to. Sometimes, for example, it's a 50-50 deal, and it's kind of split down the middle in terms of control and economics. Other times it's completely opposite. Sometimes someone who owns 60% of the economics doesn't control the company. You kind of split the economics from the management. So there's a million different iterations, and it really just comes down to what you and your partner or partners thinks makes sense. So happy to chat with you offline about your particular situation. But yeah, unfortunately, there's not a kind of one size fits all out there. Raising capital. So we always joke that, we get entrepreneurs take risks, and that's how you're often successful. And so that's great. There's two areas you don't want to take risks, and you want to do it by the book. One, most people get, which is you got to pay the tax folks, both state and federal. And so people usually understand that they're not going to let you slide on that one. The second one people often don't understand, and that is making sure when you are giving out pieces of the company in particular raising capital, that you follow the federal and state securities rules. If you don't, it is a felony, not something you want stapled to your entrepreneurial resume. And the rules are fairly complicated. So you want to engage counsel who does this all the time, not a once every 2 years thing. We can help guide you through it in a fairly seamless fashion, pretty little brain damage. But it is really important to do it. And we've seen, even since I've been here almost, like I said, 21 years, I have not seen over that time any increased kind of attention paid to these rules. Folks either don't know about them, or they say, yeah, you know what? I don't see other people in my space doing it either, so I'm just going to kind of let it slide. And again, it's not a traffic ticket if you get caught. It's not just company liability, it's personal liability for the founders, and it will make life very difficult, if not impossible, to kind of continue to do what you're doing or do future entrepreneurial stuff if you get tagged by the regulators. So when do you have to pay attention to this? Well, before you start going out and offering potential ownership, and this could be in the form of equity, it could be in the form of a convertible note. So it's not just equity. There can be a number of different iterations on that. Some people use these safe instruments. So before you go out and offer opportunities, you have to pick a legal path. There's a number of paths available, and you have to pick a path that meets your particular kind of parameters. And you see some of those on the screen there, which include the number of investors, the sophistication level of those investors, how you're planning to solicit those investors. So we typically meet with folks and say, hey, you've got, based on your parameters, one option, you've got 3 options, and then you figure out if you've got more than one option, what is the most, which option has the most likelihood of success, and you kind of pick your path. There's certain documentation that's required. It varies depending on the approach you're using, but just really, really critical that you kind of get this right. We have some freestanding presentations on this topic where we talked all about the ins and outs. So encourage you to check one of those out or reach out after. This one, we always see folks sometimes come up after a freestanding presentation and say, hey, I didn't hear about the rules, didn't know they existed. What do I do to kind of get compliant? So the lesson learned here was a few years back, but pre-COVID, when all these presentations were live, and it comes up after, says, hey, I've been doing kind of small real estate deals here in Phoenix. Not a big deal, but haven't heard of these rules, certainly haven't followed them. Can you give me some help so we do it right going forward? Sure, happy to help. Comes into the office, gave him some homework. He went off, came back a few weeks later with a couple of buddies. I don't think he wanted to do the homework, so he brought them to do the homework. We sent him back again. And about 6, 7, 8 months went by between the presentation and the third call, which third call was not the charm. He said, hey, I want to meet urgently. I've gotten my 3rd notice, which is the first mistake. You don't want to wait till your 3rd notice, but he got his 3rd notice of criminal investigation from the Arizona Securities Commission, and that is a bad day for him. And so we offered to set him up with folks here that could help navigate through. We had no idea if he did anything wrong or not, but someone obviously turned him in and put him on the radar, and the regulators kind of have endless resources and time to pursue these issues. And he actually left the state, never to return. I don't think he's, and this was a while back, and I Google him every now and then, and I don't think he's come back to Arizona. So basically, it's a life-changing situation when you get on the radar, and that's just not the place you want to be. You want to do it the right way. It's not expensive to do it the right way. Again, can navigate it with very little stress or issues, and make sure that this one is buttoned up before you would get yourself sideways. Number 6, failing to protect your IP rights. Every company has IP, even if you're not a company that sells widgets, which you think, well, maybe I'll get a patent for that. Every company, even if it's just your brand, has the ability to, A, has IP, B, needs to take steps to protect it. You could have potentially patents if you're, again, selling widgets. You could have, or even software can be patented. Trademarks, which you trademark your name, your logo, your catchphrase. Copyrights attached to your content. Some people have lots of content, and that's kind of the core of the business. Or a trade secret, a proprietary formula for your product, for example. An IP audit is a great way to figure out what do you have or what might you have. Confirming, do you own it? The law is not intuitive in many places. This is one of those. So to the extent that you hire an independent contractor, for example, and you pay them to, say, build your website, you don't own the website. The rule defaults to the contractor, even though you paid him. Doesn't make any sense, but you need to have some magic language in your agreement with that company or individual to make sure when you make the payment, you own the stuff. And that seems to make sense, but it's necessary to put those types of documents in place. There's lots of ways, both informally, but certainly legally, to protect your intellectual property, including filing patents and trademarks at the U.S. Patent and Trademark Office to get nationwide protection, including having that assignment of invention language so that you can make sure you own the work product. And also using restrictive covenants, which are enforceable in Arizona, other states not so much, but still in Arizona, they are enforceable if drafted properly. Again, there's not a one size fits all, but if drafted properly, they can be enforced. We work on those all the time and help clients enforce those. The I'm trying to be mindful of time, quick lesson learned here is we had a company whose kind of core value was the trade names on their products. Nothing real proprietary, but great trade names, resonated in the marketplace, going to market, selling the company, $30 million deal. And the other side, the buyer finds out that they don't own any of these trademarks because they never got that assignment of invention language. They had contractors creating the trade names, didn't get the magic language, and the whole deal was held up because they didn't do that. It's really a few sentences, half page of paper. It's not a lot of effort, but they didn't do it. So the deal was supposed to close at the year end. We had to chase people around the globe because they were on vacation. And fortunately, this one ends well. They were still on good terms with these contractors. So they were able to get them to assign the trademarks officially without getting extorted for potentially, 6 figures or even 7 figures worth of extortion payments to get them to sign them, and the deal closed. But imagine losing a $30 million opportunity because you didn't get folks to assign to you what you thought was yours all along because you paid for it. Number 7, another area we could talk all day about employee issues. Want to highlight a few key things. The latest stat I saw, and it obviously changes by the day, at least half the employees are looking for a new job. I mean, it seems to be off to a fairly fast start here in the year. A lot of optimism in the business community, which is great. But a lot of employees saying, you know what, maybe it's time for me to take a second look at what's out there. And so, you may have folks you're trying to keep in-house, good talent. You may have targets at other companies you've always wanted to bring over, and now may be the time to try to attract them away from their current employer. There are 1,000 ways you can kind of misstep in the employment arena. And if you haven't gotten a kind of a checkup on this, I encourage you to do that. There's a proper way to bring people in, a proper way to send them on their way if they need to be terminated. Doing so incorrectly, as we'll talk about in the horror story, can lead to all sorts of unfortunate and unexpected liability for the company. I heard a new phrase recently, some of you may have heard of this, called the Great Detachment, which is an inevitable result of folks wanting to work remote and then figuring out, you know what, I don't really feel connected to the company. I have no solution for you as to how to fix that problem. It's going to be an ongoing challenge, I think, for all businesses. Some are pulling people back in, some are trying to do some kind of a hybrid approach, but figuring out what employees want and understanding that's not just a one size fits all either. It's very generational. Lots of folks in different generations want different things. There's a great study that MetLife does. If you haven't seen it, it's free to download, and it gives you kind of breakdown by generations as to what people are looking for. It's probably pretty surprising if you haven't read it before as to what your employees may be interested in getting. And I just list on the screen there. We don't have time to go into detail for time's sake, but there's lots of different ways to motivate folks, including ways you haven't thought about. Particularly, we use the liquidity bonus quite a bit when folks say, you know what, I don't want to give out equity to my employees. I'm not interested in that. I want to be the sole owner and controlling party, but I want to give them a piece of the pie if they help grow the company and I sell it for a lot of money someday. I want to give them a piece of that, and that's what they want as well. So there's a very easy way, comparatively, to put in place a program to kind of make that happen. Other hot button issues that aren't going away anytime soon, and in fact are getting, becoming increasing issues as states clamp down on these things, is the one I mentioned a few minutes ago, making sure that people are properly characterized as employees versus contractors. just because you and that individual agree that they can be a contractor doesn't make it so. There's federal and state rules of all kinds that determine whether that person is properly characterized. Then when you bring them in, if you do, you say, well, I'm going to make them salary because I don't want to track hours. That's a big pain. And again, there's rules that determine whether they can be a salaried employer or not. Getting it wrong has fairly significant and personal liability attached with it. If you don't have a kind of zero tolerance workplace for the discrimination, harassment issues, those claims can be catastrophic. You can't prevent some rogue employee from doing stupid stuff, but you can put in place policies to help minimize, train people, minimize liability for your company. If you haven't done that, that may be something to think about in the new year. Lots of horror stories. I'll tell one that's more recent. We had a company that was had hired both contractors and employees, just kind of didn't really focus on doing it the right way. Was teeing up I think this was going to be a $50 million deal, and found a buyer. And that buyer said, you know what, we're doing our homework here. We're doing our due diligence. And it looks like you have some people that probably should be employees. You need to fix that because we're not going to inherit that liability, those issues. So go fix it and come back to us. They went and fixed it pretty quickly, to the dismay of some folks who wanted to be contractors. Now we're on board as employees. Only took maybe 2 or 3 months. But when they went back to the buyer to push ahead with the deal, the market had changed. The industry had changed for that particular company. And the buyer said, you know what, we hate to say this, but we're going to have to pull the deal off the table. So that deal went away and is still gone. I think it's gone for good, from what I just heard recently. And that was again, one of these unforced errors that you could have fixed, and certainly fixed at any time in the life cycle of the company, brought everyone on board, characterized them appropriately. But that payday is permanently gone now, at least from what I heard recently. So just one of many things where people, again, are finding out. The other issue people find out is they kind of take forms off the internet, or they borrow some forms from a buddy for those restrictive covenant agreements. And then they find out that those aren't enforceable because they weren't properly drafted. So they're sitting there at night thinking, hey, I'm protected. If people leave and start to compete or solicit my customers, I'm protected. And then they call us and find out, you know what, we're not sure where you got that form, but it doesn't really apply, or it's not drafted appropriately, and the courts won't enforce this. So you're kind of out of luck. And that's an unfortunate message to deliver, particularly when they could have gotten it in place correctly. Failing to use commercial contract best practices. So I'm a big advocate of creating your own forms. It is the epitome of kind of penny wise, pound foolish to let others give you their forms, because they will not protect you in any way. They often don't even really often have the business terms properly characterized. So putting your own forms in place saves a ton of time, a ton of money, de-risks the business substantially. For example, having standard set of hiring documents, a standard customer agreement that you give to your customers and make them sign up, or at least react to that if you have some bigger customers, and then let them try to negotiate a few points, as opposed to each and every customer comes in, you've got to engage with their agreement, which again is not going to protect you whatsoever. And then you've got to spend more of your time, maybe more legal fees, kind of going through it. It's highly inefficient, and you end up at a much worse place. You also want to set up an appropriate process to kind of engage and facilitate internal review of those contracts. Educate yourself on the key terms. I have just a few of those on the screen there. Go a long way to making your business run more efficiently, more cost effectively, and reduce legal fees, which of course everyone's interested in. Just a quick note on what we see all the time. One example that was sort of funny, but not really for the client. They had borrowed a form from a buddy who had their own business, and said, hey, we need kind of an agreement for, I think it was a vendor agreement or customer agreement. It's been a while. We'd like to use that. Hey, do you have a form? Yeah, let me show you what we did. And we had an attorney put it together. It's really good, and so forth. So they put it in place. We hadn't been involved with it. Guy calls up, says, hey, I'm really concerned. I've got someone who's threatening to sue me, and I've got this agreement in place that I borrowed. I think it protects me, but I'm not sure. Can you take a look at it? And this claim would have wiped out his company. It was a small business, like I'm sure many of you have. And had the claim been, had they tried to have to pay the claim, it was big enough it would have wiped out the business. And so calls me up a little bit later that night and said, you know, I feel better. I see in there's a limitation liability, but I want you to still review it because I just want to make sure I'm okay. So took a look at it, called the client the next day. Hey, I've got some bad news for you. Yeah, that clause in there, you do have a limitation liability, but it protects the other side. So what do you mean it protects the other side? So yeah, it's great for the other side, but it's not good for you. Well, wait a minute, my guy gave me this. I'm sure he wouldn't have done this to me intentionally. He said it, you know, his lawyer drafted it. It's great. I said, well, go ask your buddy. Well, what did he draft it for? What side of the equation was he on when he put this together? And of course, he found out it was drafted properly, but it was his buddy was sitting on the other side of that relationship. So it was drafted appropriately for that. He was on the other side. And so he had absolutely no protection. And that claim ultimately got settled, but came very close to putting his entire business out of business because he didn't limit his exposure. And that contract, whether again it's customers, vendors, etc., if drafted properly, can really reduce your liability, not to zero, but can substantially reduce it versus uncapped liability that again with one claim could knock you out of a business there. So this one, anyone that's been involved in arbitration, litigation, this will be very familiar. And you simply do not want to get involved in disputes. It is enormously expensive. It distracts from the business. It's highly stressful. Sometimes, and lots of folks say that the stress is worse than the economic impact. And so here are just, for time's sake, I'm going to kind of pop up on the screen here, just a lot of key ways that you want to kind of keep in mind and train your people to help identify when these things percolate and could give rise to claims. You know, people getting emotional about stuff. I mean, I've got one of these literally on the plate this morning where two sides are fighting about 20 grand. It's not a ton of money, but they're both extremely involved in this dispute. We'll see how it ends. Hopefully we get it resolved. But sometimes people will be willing to spend, if they have it, more money to fight about, you know, an issue than it's worth. You know, it's a $50,000 claim and they're going to spend 300 grand to fight about it. We had a intra-family dispute recently where the difference in the parties, kind of what they were willing to settle on was 3 grand. 3 grand was the delta. And they hated each other so much. And again, these were family members that they wanted us to kind of file a suit and fight and spend tens, if not hundreds of thousands to fight over 3 grand. We said, that's not going to happen. That makes no sense. Let's just get it resolved. And we fortunately did get it resolved, but that is the kind of motion that can drive these issues. Failing to communicate is another big one in this kind of technological age where people trade texts and other social media exchanges as opposed to sitting down live or at least doing a Zoom call. That leads to a lot of misinterpretation of what the other side is thinking, and people get roused up and kind of launch off without realizing maybe there isn't even an issue there, but I'm interpreting that there is one. Having no agreement or poorly drafted agreement, that should be obvious. Kind of the Phoenix is famous for the handshake deal. Don't do that unless you want to end up in a dispute someday. Lots of ways to avoid that. Other things like 50-50 partnerships, which sound great in theory. You've got to have a way to navigate through those inevitable deadlocks. How does one person, you know, exit the company if they find out they can't work together? And probably one of my favorites is just doing business with unethical people. There's lots of ways these days to figure out who your potential business partner is. So do your homework. Ask your, you know, service providers, your lawyers, your accountants who may have run into these parties before. You know, are they good to do business with? And if they aren't, maybe think about a different partner. The best agreement is not going to protect you from someone on the other side who's looking to exploit that relationship from day one. And the strategies to reduce exposure are kind of the opposite in most cases. Being an entrepreneur is risky enough, so take informed business risks and take off the table all the issues that you can. You know, mitigate all the risks you can and leave, you know, only the ones you can't control in play. That's risk enough. I guess the final note here is to think about engaging with a neutral third party, someone who's not in the heat of the battle, to figure out kind of a reality check. You know, is there really an issue here? And if there is, what's your position in the dispute? Lots of folks kind of come in guns blazing, and we say, you know what, you really don't have a lot of leverage here based on the facts, based on your agreement or the lack of an agreement. So we need to proceed a certain way, whereas other times, the opposite is true. But kind of getting a reality check, not shooting out emails and texts and voicemails that are come back to bite you if you ever get to court. Those things can destroy your credibility very quickly and tend to get out there in the public, and it's embarrassing on that front as well. So think about before you fire off, and we've seen, as you might imagine, tons of people, really smart people, fire off stuff that they wish they hadn't done, kind of in the heat of the moment there. So think about not doing that, getting a reality check before you go into the process. And I guess the lesson learned here is, and we've seen it time and time again, I mentioned a couple examples, people will spend a lot of time and get very engaged and sometimes act very illogical. And sometimes the result is, it's not worth spending a year in this fight. You may be completely right from a legal standpoint, from an ethics standpoint, but sometimes you pay to resolve disputes and move on. It's just not worth, the energy and engagement and damage to the business. And so that's a tough message we have to deliver sometimes, but one that often makes sense. Final thing is here, and I know we're running low on time, is to make sure that you run your company on a daily basis as though that liquidity event may happen tomorrow. Life happens, COVID hit, you may get sick, the company may, a big competitor may come on the scene. And so you never know when that liquidity event is going to be triggered. People say, well, I'll build the company and I'll sell it, 10 years from now. That's the goal. But you may find that in 3 years, you're forced to decide whether you make a move. And so doing the right things on a daily basis, including the other 9 categories of stuff we talked about, makes it so when you confront that event, you ensure that you're in the best place possible. The company's cleaned up, it's minimized risk, it's maximizes potential as strong as it can be to confront that event. And planning for that event is important as well. Have a plan A, of course. We see lots of folks who don't know, for example, when to or how to value the business. And so they run the business for 10, 20, 30 years thinking, hey, my buddy got a 6 times profit multiple. And so I think I'm going to get that too. And so they build the business and do the math in their head, only to find out, and this is truly tragic, that, hey, my business is only going to command 3 times profit. And so I didn't know that. I wish I knew it 20 years ago. I didn't know it. I didn't find out about it. And so we see people selling the business. They're in their late 50s. They're in their early 60s, maybe older, and figuring out that they, instead of retiring and going off to some island, they've got to pay off debt, wind down the business, and there's just enough left to maybe go on a nice vacation. They've got to get back to work. And that is a truly tragic, but truly avoidable situation by, figuring out ahead of time, again, how the business will look come sale time. It all depends on industry, size of business, et cetera. All things you can learn about in advance and figure out what your exit strategy should be. So encourage folks to get a legal checkup. We do, I do in particular, lots of what we call legal audits to kind of come in and kick the tires and figure out which areas of exposure do you have? What are the best practices you're not doing? What are some of the holes in the documentation that may make sense? What are some of the things you do have in place that, laws have changed, you need to update those. So to the extent folks are interested, always happy to offer that. Typically it's a free opportunity, and we gather some information and kind of give some feedback and tell you what things you may need to think about addressing here in 2025. So I'm just going to tell you, and I know we're just about out of time here, so let me just tell you about a few kind of upcoming programs that are coming up in the next couple of months. You can check out my personal website where we host all the listing of all the programs. They're almost all, if not all, free. Most of them are virtual, so you can log in as you did this morning. So feel free to check that out at your convenience. And for those who are familiar with the Emerging Business Program, we've kind of done a new launch this year. We're going to have both hybrid approach, both live and some virtual programs. So our next one is coming up in March on top 10 legal mistakes to avoid in the employment arena. So feel free to register for that. We've got that registration link going out shortly. So I know we're out of time. I don't know, Robert, if we have any time for a couple questions if we have them, but happy to answer those.
Yeah, we'll take a couple of minutes. It's okay to go over it. We know if you have to jump off because we were supposed to be done at 10. We understand that, but we'll take a couple questions here. We have a couple real quick ones we'll do. There's 2 in there, so we'll just hit those 2. But the first one is from Rachel, says, who does or how do you do an IP audit?
Yeah, so good question. We can help you work through that. We've got lots of folks in our intellectual property practice group, and typically it's kind of a subset of that legal audit I mentioned a minute ago, and it's basically collecting some information and helping you think through, what IP you may be generating in the business or already have generated, and how best to protect that through a combination of stuff. So if that's something that you're interested in chatting about, shoot me an email and we can connect you up with the folks who do that stuff all day long in terms of patents, trademarks, et cetera, and can give you some thoughts on what may be appropriate for you.
Excellent. And then one more, and this ties with kind of what you wrapped up. It says, can you speak to types of business insurance that may be helpful in case of legal disputes?
Yeah, that's a great question as well. So I would say there's 3 lines of protection for you. The first line of protection is your agreements, which we've talked about, putting in place appropriate employment, customer agreements, et cetera. The second line of defense is that insurance. And so depending on the type of business you're running, different types of insurance are appropriate. There's your typical general liability insurance. There's going to be a workers' comp insurance required if you've got employees. And then it starts to get into your specific type of business. If you're dealing and collecting information, for example, we just had a client get hit with a data breach. And so those can be very expensive. And so, to the extent you're collecting that information and there could be a breach, it wasn't their fault, it was a third-party provider, but that protection, having kind of cyber protection, if you will, or that covers those things may be appropriate for your business. If you've got lots of employees, there may be, policy that covers kind of employee misbehavior and theft and other things like that. You typically want to have a director and officer policy that protects directors and officers of the company if they get swept into, a lawsuit where the person sues the business and the participants, it happens a lot. That can protect and provide some funds to help you get out of that type of situation. So you want to get connected up with a good insurance broker who can kind of knowledgeable about these things, can kind of right size the type of protection that's appropriate for your business. But I think that is a very important kind of second line of defense. And of course, the final line of defense is putting in place that corporate shield that we talked about. Those 3 things together hopefully prevent any of those creditors from ever getting at your personal assets.
Excellent. Thank you, Brian. I want to thank everybody for being with us today. Again, we want to thank Brian for sharing this great information. We appreciate Snell and Wilmer's efforts to be with us on the boot camp, and Brian in particular. We hope everybody enjoyed it, and we will go ahead and wrap up. Thanks for staying a little bit longer today than right at 10, but we're glad to have this information. So we hope you can join us next Tuesday on next Tuesday's boot camp. Until then, everybody have a great rest of your week, and we'll see you soon. Thank you.
Thanks. Take care, guys.